Hey guys, one of the things I'm going to ask that you do is like and subscribe to this video. It's so important. If you are a paralegal, if you are injury staff, if you're even an attorney, you need to know how to maximize the walking around money that your client has, because it's not just important to get a good settlement for your client, but you also want them happy and to have as much walking around money as possible. Watch this video. It's worth so much. I just ask for one thing: like and subscribe. See you soon. We are joined today by an attorney and a lecturer in the space of maximizing client recovery, a man that knows liens, Medicare lien, ERISA liens, whatever, backwards and forwards, and has built a career as a legal practitioner and lecturer in that specialty. His law firm, The Place Firm, recognizes a guiding principle that the injury victim is more in need of the settlement funds created by the trial attorney than any other party. Let's read between the lines here. Uncle Sam has his paws in every little bit of our lives. Shouldn't the funds and proceeds from an injury, a collision, whatever it is, shouldn't as much of that go to the actual injury victim as possible, right? What a novel concept. Well, when you reduce liens, when you reduce obligations to the government legally and ethically, that makes for a happy client. So if you want to be educated about getting your firm to have happy clients, maximizing the walking around money for your clients, you want to listen to this podcast. So let's welcome Dave Place to the Injury Paralegal Podcast.
Thanks for having me. Glad to be here. Look forward to sharing some information today that I hope the paralegals will find useful in reducing the amount they owe Medicare.
Thank you. We're looking forward to it.
What I'm going to talk about today are some tactics, some tips, some real life steps to be taken in the handling of your cases to avoid problems down the road. In the lien resolution area, very typically, this is an area where paralegals are left on their own. Often, paralegals are very well versed in this area of law. They understand the logistics of who they're dealing with, and they're comfortable with talking about what kind of deals are reasonable. The trial attorney, I often hear from them, I always get a third off. That's because they remember that one case they got involved in. The paralegals know it's a much different reality. In fact, there are cases in Medicare where Medicare takes all of the money and the injury victim gets nothing.
Wow.
Yeah, it's terrible. It happens every day. People are unaware of it.
It does, especially when they don't have health insurance, and you have that to deal with, and they don't have health insurance that picks up after Medicare pays. That can really bite into the settlement.
And you're seeing it more and more, especially with the rising cost of healthcare and the lag or even the opposite effect of lowering minimum coverage requirements on auto coverage in different states. So you have $25,000 coverage, and that doesn't even cover a broken arm anymore. So if you have an injury victim who's on Medicare and they get severely hurt in an auto accident, the Medicare claim may well be, over $25,000. Their attorney gets all the available coverage, and it's only $25,000. The law says the attorney gets his fees and costs, Medicare gets the rest. The injury victim gets nothing. We'll talk about how to fix that problem, but before we even get there, Medicare has really turned up the heat on trial attorneys on making sure that they're paying Medicare back. I'm going to talk about several cases around the area and around the country where the Department of Justice has gone after trial attorneys directly for failing to repay Medicare. And it's important to remember this law hasn't changed since 1980. This is not a new change in the law. Medicare is simply running out of money, and they're looking for everywhere they can to get it. So in 2018, Medicare went after a law firm and said, Congress enacted these rules to ensure timely repayments from responsible parties, and we intend to hold attorneys accountable for failing to make good on their obligations. That was 2018. And in 2019, they got a $250,000 settlement from a firm in Maryland. And this happened here is Maryland. This firm had outsourced and hired a vendor. Now, my firm is not a vendor. We're actually a law firm, but I'm aware of the vendors out there who do this kind of work. We do Medicare conditional payment resolution as well. Whether I'm involved in it or a vendor's involved in it, you cannot wash your hands of responsibility. As they tried to do here, we say, oh, somebody else was taking care of it. It's not us. The Department of Justice said no. Anybody who receives a portion of the settlement is responsible. And again, they intend to hold attorneys accountable. Later in 2019, Science and Kirk in Baltimore, a firm we all probably heard about here in Virginia, got hit for $90,000. They simply weren't repaying Medicare. Last year, a Philadelphia firm got tagged. And they said, lawyers need to set a good example and follow the rules of the road for Medicare reimbursement. If they don't, we'll move aggressively to recover money for taxpayers. Now, I've talked to the attorney who's been handling those, Eric Wolf. He's got promotion out of it. He's a very nice guy. He honestly thinks he's getting money back for the Medicare Trust Fund to make it available to Medicare beneficiaries. In fact, he is. In fact, as draconian and as bad as all this sounds, the compromises that the government enforced really are not anything other than, frankly, do your job. They required that the law firm set up a responsible person in the firm to deal with Medicare secondary payments, to train that employee, and then to ensure compliance with the Medicare protocols. Again, I'm talking to paralegals here. You know the process. You have to report to Medicare, tell them about the settlement, pay the final demand. That simply wasn't happening here in any of these cases. It generally happens. You have attorneys who practice for 40 years. I knew an attorney in Maryland who lost his license. He just kind of jerked around with the lien, thinking that's what he'd always done. And Rawlings got tired of it. Ended up making a bar complaint, took his law license. So when you're working on a Medicare lien, and I know calling Medicare, the first thing you hear is you're being on hold for 20 minutes. I know it's a frustrating part of your existence. And maybe the trial attorney doesn't quite value or understand the amount of work it's taking you to comply with it. Make sure he or she is aware that you're protecting them. It really is key. And the heat has been turned up. I mean, Eric got promoted out of this. I'm sure his buddies in the law, saw him get promoted out of this. I mean, they all see, hey, this is a way to get advanced in our career. And again, they think they are doing the right thing for our government. So and I really can't castigate them like I will George Rawlings later, because they frankly are putting money back in the Medicare trust. They're just taking it from vulnerable people to do so.
Let me ask you a quick question here.
Sure.
You mentioned how they jerk around with these liens and they don't take them seriously. Give me some examples of, what a paralegal might see in the office that would indicate, hey, this attorney or, other staff members need to take this more seriously. What are they doing? Just paying some of the, partial bills of providers and just saying, well, forget about it.
Exactly right. They'll say things like, well, they may just simply not notify Medicare. Beneficiary rolls in with the claim. They make their lawsuit and they never bother to put Medicare on notice, thinking they're just going to slip through the cracks. The reason that can't happen, and again, it happens usually for older practitioners. The reason that can't happen anymore is, frankly, 2007. This is way in the weeds. Medicare requires insurance carriers to report all settlements to Medicare beneficiaries that are over $750. So there's no more crack to slip through. If you don't report the case to Medicare yourself, the insurer is going to do it about 90 days after settlement. And that's what's happened here. Some attorneys just don't pay attention to it. Other times, attorneys will be dealing with a Medicare Advantage plan. They think the Humana has been paying all the bills. Their client tells them that they've checked the bill payments from the provider, and they just make a mistake. In fact, let me just take a moment to talk about that issue, because that is a pretty big issue now, Medicare versus Medicare Advantage. And how do you deal with those? The benefit with Medicare, which I can't believe I'm saying is a benefit, is there is a BCRC and there is a Medicare portal to use, which you can go to and get confirmation of what Medicare paid and confirmation that their lien has been satisfied. There is no central repository for Medicare Advantage plans. There are hundreds of them by dozens of different insurers. Neither I nor anybody can really nail it down. And they use that. Humana in particular uses the inability for the trial attorney to locate that particular Medicare Advantage plan to their benefit, because they know that later on their rights are going to be increased if you don't put them on notice and don't deal with them. In fact, it can even happen that because of the confusingness of Medicare, where you come on and off eligibility each year with the enrollment period, your client can be on Medicare for some period and then go back on Medicare Advantage and then go back on traditional Medicare. So you may be dealing with Humana on a claim that is accurate, but there's also a Medicare traditional claim, and the reverse can be true. You're dealing with Medicare. There's also a separate Medicare Advantage claim. So unfortunately, and luckily I'm talking to paralegals here, there is simply no substitute for the legwork of grilling the client for their insurance cards and going through those bills. There isn't any substitute. There's no magic formula to figure out. Medicare is not going to say, oh, this person's on a Mutual of Omaha plan. They're not going to say that. They're just going to tell you they're not on Medicare. What complicates this even further is all Medicare eligible individuals get their red, white, and blue card. So your 98-year-old injury victim shows you their Medicare card. They're sure they're on Medicare, but in the past 20 years, they've been on and off it each year. So you really need to check those things. There really is no substitute. And the key is both Medicare and Medicare Advantage, the attorney is personally liable. So make sure you let the attorney know that he's on the hook. And in the Medicare Advantage context, Humana doesn't even look at the beneficiary anymore. They only file suit against the trial attorneys because that's where the money is. Okay, that was all the negative about Medicare, but we could spend all day talking negative about Medicare. I'm sure you have lots of war stories of dealing with Medicare.
Yeah, I had them today, actually. They claimed that they were owed money, and we had all these records of paying them. And I mean, that's how bad it was. We literally paid these guys, and they were still seeking the money.
Well, that can happen.
Months later, and they had previously acknowledged that we paid everything. That's the trick.
I had a question the other day, and exactly on that point, and that's just an error. Usually that error comes from exactly what the Section 111 reporting. You've notified Medicare, you've done what, then the defense counsel sends their notification in, Medicare screws up. I mean, I don't have to tell anybody on this broadcast how bad Medicare screws up. They regularly do it. So they just make a mistake, open a new file, and then you have to go through the legwork of getting it closed down.
Yeah, exactly. And I don't mind handling that and fixing that little error, but it's also how it looks for the former client. Hey, you're supposed to handle this. You said you handled this. And it's just like a kind of a nightmare even to deal with that. But, it's par for the course.
Absolutely. That's exactly what can happen is Medicare, because of their errors. And I say this to lots of trial attorneys when the paralegals aren't in the presentations. If there's a problem with Medicare, it's very likely not your paralegal's fault. It's probably Medicare. They're always making these kinds of errors. The one nice thing at Medicare, and if everybody on this presentation isn't using it, you absolutely should, the Medicare portal. It is a little bit difficult to get on the portal. You have to send information in. They send it in the mail, and they get passwords. You set up an administrator versus a manager versus a user. After you've gone through the labyrinth, it's worth it. Once you're on, you can see all your files, you can dispute, you can upload letters, download letters, you can get the screenshot. I send them all the time of what exactly is happening on a file at that moment. It'll tell you when the next letters are coming out. Like if you log in today, it'll say the rights responsibility letter is going to be mailed on March 21st. So it really gives you that kind of connection, which I think half the time the problem with Medicare is you don't know what's going on. They have a 45-day response time to correspondence. 45 days when you send them a letter. So I'll often have attorneys contact me and say, Dave, Medicare, I don't know what they're talking about. I've sent them 4 letters and they're responding to this other one. That's exactly what's happening. They're responding to your first letter and you've sent them 3 more in the interim. And it feels like you're not talking to anybody because frankly, you're not. You guys know exactly how it works. Now, the portal can save you a lot of that because it puts a lot of the control in your hands. I think it's like, I say dealing with Medicare is often like defensive driving. You can't control them. You can only control you. So use the portal. It has lots of functionality. It's the exact same tool my firm uses. Any lien vendor you're hiring is using this exact same tool to do everything for you. It's free. Use it. My firm and others do waivers and compromises. I charge a fee for that, for getting a refund. You can do all that on the portal. Really important tool. A lot of attorneys use, especially older attorneys, use log on as though they're their client using mymedicare.com. That's an incredibly cumbersome way to go about it. You don't get the same pictures and you have to do it for each client. This logging in the portal, you can check all your clients very fast. So it's much easier for you in the handling of all of your Medicare cases. The forms, actually, I believe these links might actually be broken. The 2 forms you need to send into Medicare is the consent to release. That's just your HIPAA form. Your HIPAA will work. And the other is a Medicare form for the proof of representation. This is the one they always give you a hard time about, especially if you're doing a wrongful death case and you have an administrator, or you have a wrongful death case and there's no estate set up because it's an indigent client. This can be a real pain to deal with. Again, it's just Medicare being a pain. Often you'll send the documents in and say, oh, we need the letters again. And then you send the letters in, they'll say, oh, we need the proof of representation again. So to avoid that kind of thing, when you send documentation in, just kind of send it all. Don't send it piecemeal. If there's a third fax to them, send everything again. Just keep doing it to make it easy for them. Really think about it as like you're trying to explain to a toddler what you want done, or explain to me because I tend to lose things and forget things too. So honestly, I kind of appreciate their business model. You guys know you put them on notice. You can use the portal, put them on notice. You can call them. You can fax them. You can mail them. Again, I recommend using the portal. It takes about 10 days for them to validate or verify the information they receive. Again, that's frustrating because they can do it instantly, but they don't. But when you're on the portal, you can log in. It'll show your file on the portal, and it will say validated. If it's not, or if it's not validated yet, you can't do anything yet. Once it's validated, you can. If you have files you've already reported to Medicare, but you haven't used the portal before, they already exist on the portal. You're just not looking at them. So you can get on the portal, have access yourself as soon as you can, and then you can see it. It's not something you set up different. It's automatically set up by Medicare. You're just not looking at it yet. Now, after you report to Medicare, we start getting these timelines. About 2 weeks after you've reported the case to Medicare, you should get a letter called the Rights Responsibilities Letter. If you don't get it, you need to call Medicare up. They made a mistake. In fact, in their own manual, believe it or not, Beau, they instruct trial attorneys to call back 1 week later after the initial notice just to make sure the notice was received. I mean, imagine if that was the process in your office. Just do everything twice, just to make sure. From this point on, if you're faxing, make sure you use the correspondence cover sheet. If it does, if you don't use correspondence cover sheet, Medicare just throws your faxes away. That's what they do. Now, 65 days after that letter, so about 90 days after you reported the case to Medicare, you get your first conditional payment summary, the list of claims. So, and nothing speeds this up. There's no special phone number. There's no backdoor email. This is how long it's going to take. So you're going to want to get involved in this process early. You don't want to have mediation last week and just get started with Medicare, because you're going to have to tell your client they wait 4 to 6 months to get their money, and they don't want to hear that.
So how important is the technical, settlement date when it comes to starting the lien resolution process?
When you're reporting to Medicare, that's one of the key things you have to inform them of, because that's when they stop counting any payments they've made for related care to start creating your final demand that they'll send out later.
Right, because you could have a settlement agreement executed by the parties, and you're waiting 1-2 months or more to get on the court's docket to memorialize that settlement.
And that's assuming that the court approves it.
Right.
If the court doesn't approve your settlement, I mean, that does happen rarely, but it does happen. And if you've already reported the case to Medicare, you're in this, they've sent you a final demand, the timer started. So the date you should use, I always say, is the date you would use if you had to go in and try to enforce a settlement. Whatever date you would put on that demand, which always will vary. It may be that you settle at mediation and releases have to be prepared. In some jurisdictions, you might want to say, no, we settle it there, and the releases, they added all kinds of things we didn't plan on. So that date is going to be very dependent on each case. Obviously, the date the release signed is the easy date. But if there's a weirdness there, it can affect that timer. Now, auditing disputing, I'll take a little time here, because this is really where paralegals can really have an impact on getting the case settled, I think. And I'm going to give you a couple tools that are not readily talked about, and they're really used by my firm and hopefully by the vendors you're using. This is during the audit and dispute phase. Now, the nice thing about this phase is you can audit and dispute 1,000,000 times. You don't have to provide any documentation. You can just say, I dispute it. They don't have to agree. They'll send a letter back saying we don't agree, but you can go back and forth. So your first dispute does not need to be your final dispute. It doesn't have to have all your medical documentation. You can just dispute it. On the portal, you literally click a button. But obviously there needs to be can't use fraud. It'd be a reasonable basis for why you're disputing it. Here's 2 good ways to dispute things that are different than saying we're not claiming them. First is something called hospital acquired conditions. Back in the days we called non-events, which I like that name in a passive way even better. These are things that the hospital did to your client, and Medicare shouldn't pay for them. Bed sores, cutting off the wrong leg, things like that. Medicare essentially says, we're not paying you, hospital, for doing this. So if these charges appear on your claim summary, it means Medicare paid them, but they shouldn't have. So dispute them. Now, we extrapolate from that. Say, oh, your bed sore is just like this other thing you paid for. So you should also dispute this one and get a refund back on that. We're about 80% successful on that, because Medicare will get the refund back. At the end of the day, your job is to reduce the amount the injury victim pays back. You don't care who pays back Medicare as long as it's not your client. So that's a really good list. That's a link there to the online list of the codes. Now, those codes, again, they're changed each year, but they've been static for a decade or more. Bundled charges. This is probably a much bigger issue for you. It comes up probably daily. Now, I'm sure every paralegal on here has seen these Medicare lists, but maybe your attorney has not, and you might explain it to him. The Medicare claim summary comes in with bundled charges. There's one big charge across the top, which is the basic general billing code that the provider is using to bill Medicare. And then the IC9 and 10 codes are itemized beneath that. Medicare makes one payment based upon that top code. but often in the underlying codes, there'll be unrelated care included. Medicare cannot pull out cannot unbundle bundled charges to remove unrelated care. It's a computer thing, just simply a computer thing. There's a great case out of California. It's actually a Medicare Advantage case, but Medicare Advantage is based upon Medicare, so it's the exact same law. And it says pretty clearly what the Medicare statute says, which is you're required to reimburse Medicare for each individual item or service that another party has become responsible for. So bundling them all together doesn't make 10 services one service. There's still 10 individual services. So what this case said was Medicare, in this case Cigna, if you can't unbundle the charges, you don't get the benefit of getting extra money. Boop, you throw the whole thing out. So what happens here is in practice, you get related charges thrown out as being uncollectible. You're not saying they're not related. You're saying they're uncollectible in the way they're being presented by Medicare. We had a $300,000 claim going on $1,200 on this.
Nice.
Yeah. I mean, they called for mediation. They wouldn't believe it was right. No one, I mean, I was sweating. I couldn't hardly believe it was right because it was a big change, but it was accurate. Think of it this way. I mean, I'm sure all of you have been on the receiving end of Medicare's incompetence negatively impacting you. This is a chance for it to actually benefit you. So that's why it works.
In essence, it kind of seems like, well, everything's commingled anyway, so it'd be difficult to figure out which is which. Is that right?
That is exactly right. And their computer systems simply don't enable them to do it. And all of us, especially a paralegal and me too, we all work for our computers. I mean, they don't work for us. If the computer says no, that's the end of the story. So Medicare simply doesn't get that money back. Interesting, in that case, they actually tried to withdraw. They tried to drop the case, tried to not make the claim. So they didn't want to have that bad ruling. And the court said, nope, we want to make this ruling. You cannot do this, which was very helpful to the court, of course, California. Now, the portal, as helpful as it is for managing the case, it really shines in ability to help you get the case settled at mediation. So let me talk about how that can work. If it's kind of like a rocket docket setup. If you believe the case is going to resolve the next 4 months, 120 days, you click a little button on the portal, a bunch of warnings pop up saying you only do this one time. You're sure you want to do it? Yes, you want to do it. You enter into this sped up process, and it gives two big advantages. There's actually a little flow chart. First is the dispute process. The problem is you only file one dispute on this process, but they have to review it and give you an answer within 11 days. If they don't, your dispute is automatically granted, like a request for admission. So that's very helpful. But the real benefit is if you think mediation or settlement conference is going to happen, you can download this letter, which is good for 3 days. And it says, this is the final conditional payment amount. It's not going to change. Now, this amount will still be reduced by attorney's fees and cost to get your final demand amount. But that calculation is easy, and I'll show you that in a second. The benefit of this letter is a trial attorney can sit down at the mediation table and talk to the client about what they're actually going to net. Before it was always, well, we don't know what Medicare is going to want, and the final demand comes back bigger and the client's unhappy. You can actually sit down and say, this is what you're going to net at mediation. This letter's only good for 3 days. So you're going to, mediation's on Monday. I want to download it Monday morning, probably, because if the mediation gets kicked a week, you're out of luck. You fall out of the process, the letter's no good anymore, and you're out of the 120-day process. There's no negative impact. You're still fine. It's a normal Medicare case. You just lose the advantage of this. Another great ability, I think, of this letter is so many defense counsels say, we'll draft the check. We'll obtain the draft once we get the final demand from Medicare. Well, that takes 21 to 45 days after reporting the settlement. So you're looking at 45 days, then 30 days to get a check to you. I mean, my God, your client is going to be calling you every day. Where's my money? So this letter you can give to your attorney, the defense attorney at mediation. No, buddy. I like that kind of aggressive tone, buddy. Here's the letter on CMS letterhead. It tells you exactly the number, exactly how long it's good for. Let's do the calculations. I think here's that together. We know what Medicare is going to want. Go ahead and request the settlement draft. And even if they want to send a separate draft to Medicare, which some of these guys do, there's no real negative. There's no downside to doing that, really. It's just, I don't know why they want to do it. But everybody can have the numbers at mediation so they can request the checks and speed the whole process up. The real benefit of knowing what to do with Medicare isn't finding the trick to get it done fast. It's avoiding Medicare's desire to cause delay. They want you to screw up. They want you to respond slowly because they simply don't care. So by following these steps, one, you avoid the risk to your attorney in the law firm. You get it done quickly, and you're able to tell your client your money is coming faster, and it's done. Now, once you've made that, I think I have the slide for the final. Yeah, the final settlement detail letter. All you ask, you can do on the portal or in fax, is the settlement amount, settlement date, attorney's fees, cost, and was there any no fault? Now, the question I got a no fault, especially in Virginia, where I know it's a little bit complicated, is that question is how much no fault did you receive directly, not how much no fault was paid to a provider. So if all the no fault was paid to medical bills, then that answer is zero. But if your client got a $5,000 check sent to them directly, then the answer is $5,000. Anticipating a question or problem on that, the reduction for fees and cost only applies to liability recoveries, UM and UIM included. It does not, they do not reduce against no fault, the $5,000. So Medicare, essentially, they look at that, you got that with no effort, right? No effort. The concern sometimes, because Medicare likes screwing things up, sometimes they will give you no reduction of fees and costs at all to any of the settlement. That's an error. You get your reduction of fees and costs on the BI or UM and UIM part, just not on the no fault part. If that happens, you've got to work with Medicare to get them to solve the mistake. It is a mistake. That is not how the law works.
So can you still attack the no fault claims on other bases as well? Like, this is unrelated, things like that.
Absolutely. It's just the idea. And what problem with no fault often can pop up, though, is that Medicare opens a liability file and a no fault file. The no fault file you'll have access to in the portal. You can see it. In fact, it's very nice if you're on the liability side. There'll be a big red bar across the top of the portal indicating there's another file for this beneficiary. So if there's another file out there, work comp file or something like that. The no fault file will show is exactly the liability file. The big problem is they will only communicate directly with the no fault carrier, not with the trial attorney. Even if you send them letters on the no fault carrier's letterhead showing the benefits been exhausted, they won't accept it. So you can be aware of that file, but you really can't impact any. They just simply will not deal with you. The benefit is they will never look to beneficiary for that number, even if they goes on final demand, even if they go to Pioneer Credit, they will never turn to the beneficiary for payment of the no fault file. And that's been the case that I've been told by every regional office and that's been the case in practice. We talked about Medicare Advantage briefly. There's also Medicare supplement plans. And I frankly love this slide of this elderly gentleman. I think that's how all of us feel about Medicare. What in the world? There's, Medicare, Medigap, Part B, Part A, Part C, Part D, donut holes, all this stuff. What is going on? What is happening? Well, frankly, it's easy to think about Medicare and Medicare Advantage, which is Part C and Part D, are essentially the same for purposes of, well, all purposes, especially for reimbursement. Medicare supplement plans, the F, G, K, L, M, I's, all the others you see, those are just private insurance. So if your state has an anti-subrogation provision, it's going to apply to Medicare supplement plans. These are plans, if your client is on traditional Medicare, they may have a supplement. If they're on a Medicare Advantage plan, they will not have a supplement because the Medicare Advantage plan incorporates all of that. The Medicare Advantage plans recovery rights, again, as I said, are exactly the same as Medicare. The real difference has been how they go about prosecuting them. We talked at the beginning as part about Department of Justice going after trial attorneys. That's a new action. What Medicare had done previously was to refer the case to the Department of Treasury. Then they would go to Pioneer Credit, their collection company, and they would garnish the Social Security benefits of the Medicare beneficiary. Now they started going after trial attorneys. The Act does allow them, as it does the Medicare Advantage plans, to double the amount due. The Medicare themselves are not doing that, they said. Humana is. They have turned this into a profit center. One of the cases out of Florida, I'll go to quickly, is the Western Heritage case. It really set the bar for this. This is a slip and fall case, about $19,000 in medical bills. The trial attorney was ready to settle the case. Humana popped up. He had a letter from Medicare saying no benefits were paid. File closed. Humana shows up right at time of settlement. His client says, I'll deal with it. Doesn't deal with it. He settles the case. Humana sues the beneficiary, but eventually drops that case and instead sues the third-party carrier, Western Heritage. Western Heritage has already paid the value of those medical bills to the plaintiff in settling the underlying case. So they put the $19,000 in trust and begin the litigation with Humana, as I would have counseled them to do. Eventually, they get to the 11th Circuit. The 11th Circuit says putting the money in trust is not making payment. And the statute says double damages shall be awarded. So you have to pay twice. So Western Heritage paid Humana $32,000, $38,000 for bills they had already paid to the plaintiff. That's why defense counsel is so nervous now about Medicare, making sure it gets satisfied. Understandably so. Case here in Virginia, I was actually the expert witness in. Humana did the same thing. They knew the attorney was going to miss a 60-day deadline and waited. In this case, the initial payments were $191,000, and they doubled them. And I can tell you, your E&O coverage does not cover punitive damages. So, luckily, the case got settled. So, Humana has turned into a profit center. They're looking for money. In fact, inside the insurance world, this has been huge class actions, tens of millions of dollars by Advantage plans going after no-fault carriers who haven't paid and have had Advantage plans make payment when they should have making payment under statutory obligations. So we're only seeing, as trial attorneys, the very edge of this. I have a slide here on George Rawlings. I always try to bring up George. They'll talk bad about ERISA. They also do Medicare Advantage recoveries. And I bring them up because, well, Optum does them, Conduit does them, but there is no Mr. Conduit. There's a Mr. Rawlings I can personify and go after. And frankly, he's not a very nice guy. He runs what they call a white-collar sweatshop. Quite tough there to work for. Most of the employees, I hired lots of them in my previous life. They sit in the parking lot cry in the mornings before they go in. It's really a tough job. In fact, I encourage you, when you're dealing with the Rawlings in particular, to remember that they are people just at work. They don't like their jobs. That's why they're so unhappy. They're a little bit trapped there. And to go inside baseball a little bit, the job requirements at Rawlings have a high school diploma. But the average pay is $72,000. So it's a very high paying job relative to the education requirements. So a lot of the employees there in Kentucky are somewhat trapped in that that environment. Obviously, I don't expect you to have too much sympathy for them, but that is why they are how they are. In the Medicare world, it's important to I single out Rawlings because Medicare Advantage plans, just like Medicare, are required to reduce for fees and cost. Rawlings says they don't have to. They say their contract says 100%, is approved by CMS, they get 100%. They are wrong. There's no law saying that. There's no statute saying that. Even public policy doesn't say that private industry gets more back than the federal trust. Doesn't make any sense. But I can't imagine the tens of millions they've made by just saying that. So fight back on that. We talked a little earlier about the attorney liability, but that really is the big issue on Medicare, is the personal exposure to the attorney, the general trend for the Department of Justice to be more aggressive in this area, and the growing profit center and Medicare Advantage plans to go after trial attorneys. So that's really what has kind of been a perfect storm out there for attorneys on this front. Are there any war stories on this front, Beau, you could talk about where you or your office have been struggling to deal with these issues?
No, we're pretty good at communicating. Every now and then they lose a payment or they apply it to the wrong account despite, the memo saying where it's supposed to go. That happens every now and then. Knock on wood, it hasn't happened.
And that's great.
To the degree that you're encountered it and the past you have in dealing with these types of issues.
And that's great. I think I was just an 80-20% rule with Medicare. 80% of the time things work okay. 20% of the time you have no idea what happened. Oh, right. And unfortunately, that happens. Used to happen more regularly when people didn't use the portal. I had lots of cases where I would get calls, say, Dave, through 2 years of litigation, Medicare was saying the conditional payment amount was $6,000. I get a final demand of $30,000. What can I do? And the law is clear. Nothing is final with Medicare until that final demand. So never rely on that conditional payment letter. Every single circuit has said that those letters clearly state they're not final. And frankly, they don't do any work until they get your settlement information. Then they do an accurate effort of going through and creating a final demand. What can happen, though, sometimes is they'll add back on charges that you've spent months disputing. And that can be that vicious cycle where your office has been doing everything appropriately the entire time, but then Medicare, puts it all in the ditch.
Let me ask you a question here. You mentioned vendors, and this is a highly specialized area where I know attorneys and firms and paralegals routinely rely on vendors and law firms such as yourselves that are subject matter experts to get into the little weeds and reduce these. How do you know if a vendor is doing their job? What sort of processes should a law firm have to check that stuff? And I ask that because the lawyer is on the hook if there's a screw up, and that goes back to your earlier example of a vendor being tasked with resolving these, assessing them, and then the attorney gets blindsided. What are some checks and balances that a firm should have to make certain they're doing their job?
Well, that's a great question. In fact, I had a client call me and basically said, Dave, can we absolve ourselves of liability by hiring you? I was like, no, you can't. He said, well, then why hire you? Said, well, there's no way to get rid of liability. There's lots of reasons to hire me. The things you should look out for in particular is timing. The knowing when these letters were received, like when they put the client on, your vendor puts Medicare on notice, they should receive a letter in 14 days. So 2 weeks after your vendor is supposed to put them on notice, they should be able to provide you with documentation from Medicare that the Medicare is now aware of this. Even sooner than that, if they're using the portal. The nice thing about the portal, and in fact, if you have a vendor you're using and this vendor is not working this particular case you can get on the portal without having the authorizations. In order to check anybody on the portal, all you know is their last name, the date of birth, the date of the incident, and their social security number or their Medicare number. And you can see you can get a very limited access to their file, seeing the conditional payment amount and some other information. So on the one side, but if you want to double check your vendor and you have a portal in your office, you can log on and see what they're doing. It'll indicate when letters have been sent and received by CMS. Another great way to make sure that your vendor is doing what they should be doing is in the Medicare Advantage area. You should be having every time, whether you refer a case from Medicare Advantage or Medicare, you should be having a conversation with your vendor. And I don't care if you had it 50 times before, you should do it in every case about what do you want us to do relative to each of these particular carriers. And I bring that up, for example, this way. You may be 100% certain your client, Humana, paid all the medical bills. You may be certain of that. You've checked them all. You may be really certain. Say, Dave, do I need to notify Medicare? You don't need to notify Medicare, but you're taking a risk, as we talked about, of not notifying them, of there being a potential claim out there. And the reverse could be true. Dave, I'm really sure that it's regular Medicare. My client's never been on Humana. Now that one I'm much less sure about. I'm going to make sure you check the bills. But you should be having that kind of conversation, not treating these as a throwaway issue that I don't have to worry about, which I think does happen because it can come back to bite you. I mean, there's $250,000 that one for 90,000 of Science and Kirk. That's real money. The one big red flag.
That's real jobs too.
That's real jobs. Yeah. That is absolutely.
Screw up like that, it's over. There's sometimes incidents like this, but for far less amounts, we could kind of say, well, this is a learning experience. When it's a $90,000, it's time to look for another job, maybe a new career.
Absolutely. I had one of my first cases 10 years ago. I switched sides. I was a bad guy before. Was I had to tell a law firm they had to come up with $118,000 out of their own pocket. And it was a young attorney who practiced 3 or 4 years. He had screwed up and he was dying going to tell the partners. Dying. He had to go and tell them they had to come out of their pocket. But there was no solution. That was it. So dealing with it really is key. Now, the one thing in particular that you should be on the lookout for and your vendor should be on the lookout for, again, because of Medicare Advantage, is if you report the case to Medicare and the conditional payment amount comes back at 0, somebody's paying those bills. And what should be happening from your vendor, if they get that letter back, they shouldn't say, oh, I got a 0 letter from Medicare. They should be saying, I got a 0 letter from Medicare. That's a red flag. We need to find out who's paying these bills. And they'll instruct you to go through the bills and grow your client. That's different than if Medicare conditional payment amount is different than what you expect. If, for example, you expect $60,000 in medical bills to have been paid by Medicare because you have the records from the hospital and the conditional payment shows $5,000. That's probably Medicare's screw up, actually, probably not an Advantage plan. But that should also trigger some warning signs. As you talked about the $90,000 being a big deal, it certainly is. But I'm sure in your practice, certainly in my 20 plus years, it is always the little cases that cause the big problems. It's the $1,200 Medicare file. It's this outsourcing of this little Medicare conditional payment you didn't even think about that is now causing you a ton of problems 6 months down the road. So that really is the factor here is that, and frankly, the ABA model rules on outsourcing to a third-party vendor require oversight to make sure that all these compliance is being done. So you really can't wash your hands of it. Your vendor think of your vendor as a partner on this, not as someone who's doing something you don't want to think about because you're personally exposed to it. And as you pointed out, if this goes back and your client gets a nasty letter, that's just anti-marketing. I mean, they're happy to talk about what a bad job you did as opposed to what a great job you did. They'll remember that a lot more than the money they spent already.
Dave, you've done such an amazing job covering Medicare, all the problems associated with it, and how to do a good job of maximizing client recovery. What should injury firm staff and attorneys do to also avoid the other pitfalls that exist? ERISA liens, TRICARE. What should they be on the lookout for, and how can they avoid them?
Sure. Let me talk about TRICARE first, actually. That's a little bit more interesting. I know we run into it quite regularly around here. TRICARE and VA in particular will send a letter called the Attorney Agreement to Protect the Government's Interest letter. A lot of law firms just sign these pro forma, and the reason they do that is because TRICARE, the different military branches, will not release the medical records unless they've gotten this letter back. Signing the letter is really up to the law firm, but understanding the obligations, I think, is one thing that's confusing. That if you sign that letter, you're agreeing to represent the government for free. For example, if the government's claim is $50,000, you sell the case for $100,000. Your fee is not in $33,000. Your fee is $16,000 because you cannot charge a fee on the dollars you've recovered for the government if you've signed that letter. So I think don't sign the letter, and then work to get the medical bills. The workarounds actually will eventually give them to you, but the reason they don't is because they do not have a claim directly against the injured victim. Their claim is against the third party, and they want you to do it for free. I recommend not signing that letter, but if you do sign that letter, and a lot of attorneys do, because it's just easier, and some attorneys are nervous about not signing it, you still can negotiate resolution of their claim, but you're not going to be able to take a fee. You're going to need to calculate your fee on the portion that does not go back to the government, so that you're not charging a fee there or have full disclosure with your client on it. So it can get a little complicated on that front. On ERISA, in particular, you're going to want to send out the statutory letter. I'll say it twice. It's 29 USC 1024B4. Again, 29 USC 1024B4. I say that statute so often it should be a middle name. Excuse me. But all that is a document request. It doesn't need to be certified, doesn't need registered mail, just be in written form, sent to the plan administrator by the plan beneficiary. Now, I recommend having your client sign that letter, not the trial attorney, because the statute clearly says the letter needs to come from the beneficiary. It's a very minor issue. If the trial attorney signs it, it's probably not going to be a problem, like a 1% issue, but why have any issue at all? And you're going to want to send that to the plan administrator. The plan administrator is never Rawlings or Optum or Conduit, never. It's always going to be the employer group. The only time it's not the employer group is if it's going to be a union, Teamster or someone like that. That can be because ERISA does allow the appointment of a non-employer plan administrator, but you never see that except in union shops where multiple shops will buy one policy and they designate the union representative as a plan administrator. So you're almost always, again, 99% of the time, able to send that statutory request to the employer, and that triggers the statute. The reason you want to trigger the statute is, one, you need the documents they have. That's almost secondary. Two, you want to begin the process of accruing penalties. If they don't give you all the documents you've asked for within 30 days, penalties of up to $110 a day begin to accrue. That's about $10,000 every 3 months. So if you do the beginning of your case, right at the beginning of litigation, as litigation progresses, these penalties are accruing. So you've given a great tool to the trial attorney or the vendor or someone like me who's negotiating the lien at the end. Because I can go to the Rawlings or the Optum and say, I know you have a claim for $50,000. We think you've incurred $30,000 in penalties. Let's start negotiating at $20,000. Now, they're not going to give you a dollar for dollar benefit, but you've created some leverage. And I'm sure, as I said at the beginning, most paralegals are the ones who negotiate these liens, not the trial attorney. You know, just need something to hang your hat on. And this gives you something more than just saying he or she's been injured, and put some exposure back on the plan. And the nice thing is the penalties have not been the result of an action by Rawlings or Optum. They've been a result of an action by the plan. So Rawlings doesn't have to throw themselves under the bus. They can say, oh, look, client, you didn't do the right thing. Now you've tied our hands. Because Rawlings wants the easy money. That's all they want.
Dave, you've done such an amazing job today talking to injury paralegal staff and attorneys. How can people reach out to you, and what kind of services do you provide for these firms at the Place firm?
Thanks. Well, exclusively, we do lien resolution. I resolve Medicare, Medicaid, ERISA, FEBA, military liens, disability liens, and any hospitals. We don't really do providers. Because generally the practicing attorney may have a better relationship with the provider. If you may use a chiropractor all the time or someone like that, and you really don't go to war with them. And often providers are, the results can vary because you're dealing with the doctor directly. He's usually not as willing to resolve matters. But we handle all of these matters on a 10% of reduction is our fee. So if I save your client $10,000, my fee is $1,000. It's always quantifiable to show the benefit we've added, and we never take more than 10% of the client's walk away. So I talked about earlier, in this world where we're getting higher medical bills and lower available coverages, it just doesn't make sense. So my fee is never more than 10% of their walk away. And by walk away, Beau, I mean after attorney's fees, after costs, and after paying a lien. I had a case last week. I saw a settle for $500,000, and the client walked away with less than $200,000. Just how it is with all those costs involved. So we take that in consideration. I switched sides about 8 years ago because I simply couldn't look in the mirror anymore. I was an ERISA recovery attorney for 15 years, suing injury victims and minors. And I switched sides, and I'm dyed in the wool to help the injury victim. So I only charge a fee if you outsource a case. If you have a question, shoot me an email to Dave@the Firm. Give me a call. I really want to be a resource for the trial attorneys out there. I may have the answer to your question readily available, and I don't want you or your trial attorney spinning your wheels looking for an answer. I had an attorney last week tell me he'd researched ERISA, another paralegal who had been reading the Medicare Act. Oh my God, call me. Don't do that to yourself. Only if you outsource it will be any charge. Questions are always free to answer.
Yeah, you've always been a very good resource for me, asking the random questions every now and then. What this comes down to frequently is you can resolve a case for a lot of money, more than fair. But what really matters is your client's satisfaction. Are they happy with the result? And one of the ways I measure that is what I call their walking around money. They might have incurred lots of medical bills. They might have all these liens, but if they're only getting a few $1,000s after dealing with this entire process, they could have had more insurance coverage, but that doesn't help them today, right? They got a family to take care of. They got obligations. Let them be happy with your services and have them come out as fulfilled as they can. And you do that by increasing their walking around money and using services like Dave, and his firm help you achieve that superior client result. Dave, thanks for joining us at the Injury Paralegal Podcast, and please stay in touch.
Thanks for having me.
Thank you.